Good afternoon, and thank you for viewing the Facebook fan page and the YouTube channel for the Law Office of Travell Travis. Our firm focuses on the needs of pastors, entrepreneurs, creatives, and the community. We invite you to connect with us on Facebook, Twitter, Instagram, YouTube, LinkedIn, as well as visit our website, travelltravis.com. Email us, travelltravis@gmail.com, or call us at area code 757-528-8529. Always as a disclaimer, our videos are for educational and advertising purposes and is not a substitute for contacting a licensed attorney in your state, nor do these videos create an attorney-client relationship. About a year ago, I started legal lesson 15 on the topic of the need for a church to have trustees or directors. In that video, I gave 7 reasons why a church may not need to do so. However, most churches would not qualify for any of those exemptions or exceptions. Thus, if we must have a trustee board, how do we select a trustee board and avoid some of the horror stories that we've heard about boards voting out the founding pastor, or as many of us from a biblical standpoint, Judas who will betray Jesus? Most states, including Virginia, require the congregation to vote or at least have a voice in selecting trustees. Why is that? Because they represent the congregation, can bind the congregation or the church legally and financially. They are entrusted with the property and the assets of the church, and are caretakers ultimately of the hard-earned money that is sacrificed by the members to support the ministry. So as I stated previously, failure to not have a board can be catastrophic. Likewise, an improperly seated board can cause problems, especially for the pastor. For example, a church purchases land or building without trustee approval, or with an improperly seated board, meaning you have one but it was not done properly. Along the lines that there's a financial, legal obligations on that property that the church cannot afford. Now we have a situation where the pastor or the board members individually are responsible for that debt or financial obligation. Why is that? Because the congregation did not approve the people who approved the debt or the purchase. And so now somebody has to pay the bill. Who's going to pay the bill? The ones who individually or without a proper authority or authorization made the commitment. And so really what it's saying is you can't have it both ways. You can't say that I'm going to do it my way with my people that were selected by me without the consent of the people. But then when there's a debt or a financial obligation or a lawsuit, turn around and say this is ours. It can't be me and mine and then ours at the same time. So there has to be a decision to properly vest those representatives from the congregation or trustee board to make those type of decisions. So the question, especially for pastors, in particular founding pastors, or those who have a little bit more of a theocratic administration, meaning there's a lot of deference to the pastor's decisions and appointments, as opposed to perhaps a congregational church in which a lot of the power is vested in the congregation, or even an ecclesiastical church where the denomination has a lot of say over the local assemblies. So if you're the founding pastor or a pastor of a theocratic church, if you will, the question is, you may have more control over who is selected and who is seated on your board. I'm going to give you 5 approaches that you might want to consider in selecting your board. Number 1 could be just a pure vote. A pure vote, we bring all the members together, take nominations from the floor, voted on by the congregation, and whoever wins gets seated, whether they're qualified, whether you want them necessarily to be on the board. They're the people's choice, no filters, no screening, pure vote, whatever the congregation, whoever they nominate and select, gets seated on the board. That's one way of doing so. The second way is to perhaps have a pre-clearance process. A pre-clearance process would allow perhaps the pastor or a nomination committee to pre-select candidates from which the congregation can choose from. So whether there's an issue, a moral issue, a financial issue, something in that person's background, or what have you the case may be, that may qualify somebody or may not qualify somebody from the board, they've been vetted before they're even presented to the congregation for a vote. Okay, so that would be more of a pre-clearance method, and then from there the congregation may vote. So you may have 5 nominees that have been vetted, pre-cleared, and the congregation can pick 2 or 3 from there. So it's not that the pastor had total say, but may have narrowed down the field, if you will. From there the congregation can make that vote. The third method is almost the opposite, would be what I consider a post-clearance method, in which you have the congregation to nominate and to vote and select trustees, but then a screening or clearing committee or the pastor can then perhaps override or make a decision that that person should not be seated for various reasons. That method is a little bit more complicated, because then the question becomes, why are you not seating the person that the people voted? And so if it's a confidential matter, a private matter, how do you explain one way or the other? Or if the vote went way, how do you override that vote? And so it allows the people to be fully democratic, select who they want without any filters, without any screening, who they want. It allows the leadership to perhaps screen or vet to make sure that they're qualified, and assuming that they are, they would be seated. But once again, in the situation where perhaps there's some private matters, sometimes only the pastor knows who's tithing, who's in financial issues, who's having perhaps some personal issues that's not necessarily known to the congregation, nor should be known to the congregation, that perhaps will make them not qualified or the best suited person at that time to take that seat. How do you then explain that without making that known to the congregation? The fourth method, which in some churches use, is the voting by the board. The board that has been selected then selects additional members or replacements. So some have argued that by the board being representatives of the congregation, they then can continue to select additional members. The board picks the board. Once again, that may be problematic, because then you have perhaps a board that's comprised of people in which the congregation had little to no say over who's sitting on the board. And so when litigation or something were to come up, that's probably something that can be exploited to the advantage of the person who's challenging the decision of the board. Now, with that said, I want to mention a sidebar is churches should also consider, and your bylaws should speak to, term limits, but term length. If someone is elected to the board, for how long? Is it a life appointment? Is it a 10-year appointment? Is it a 5-year appointment? Is it a 2-year appointment? And so depending on, there's some advantages of longer term, so maybe you don't have to have the voting. Every time you turn around, there's a vote taking place. But on the other hand, if you have someone that is not suited for the board, or someone who is better suited for the board, do you have to wait until that 5 or 10-year term expires? So we look at, even in our United States government, senators have 6 years, president has 4 years, congressmen have 2 years. And so you might want to consider what's the appropriate term length, and even maybe term limit for members of the trustee board. The second thing you might want to consider is, how are people replaced on your board? What is the criteria for replacement? And then secondly, who gets to make those replacements? A board member retires. I don't want to be on the board anymore. They resign. They perhaps have terminated their membership with the church. Or there may be grounds in which a person needs to be removed from the board. One, are those things spelled out in your bylaws? And then number two, assuming that any of those events occur, who gets to select the replacement of that individual, especially if there's time left on their term? And so if the pastor has the authority perhaps to make that appointment, say, okay, there's a 4-year term, person completed 2 years of the term, I'm going to appoint someone for the remaining 2 years. Although they'll be up for election at the end of that 4th year, they will be an incumbent rather than a newcomer. And so they may allow the pastor to say, okay, this is somebody I want, I'm putting them on the board to fulfill the remainder of this term. And then after that term is up, they're then voted upon, and assuming that person has done a good job and is well favored with the congregation, then they most likely will get reelected to that position. Now, the fifth method that I want to propose is probably one I've seen recently that kind of allows the best of both worlds. And that is for the pastor to appoint, but to have the congregation affirm or ratify those appointed to the board. So the pastor says, I'm appointing X, Y, and Z to the board of trustees, and all in favor say aye, all opposed nay. And assuming that they're well qualified, that it's a good group of people, there's a lot of respect for the pastor, especially once again in a theocratic governing church or founding church. Simple process, you check the box, you got to appoint who you want. Box number 2, the people got to approve, and we didn't have a big mess, big long drawn out election process. So the appoint and affirm method may be something that you may want to consider if your bylaws permit it. In closing, I want to remind founders, especially, of their obligation, but also privilege as founders. As founding pastors, you get to select your initial board. The number, the IRS requires a minimum of 3, but you get to select the number of board members and who serves on the board, so long as not all the board members are related by blood or marriage. So when you're talking about that initial board, if the church is incorporated or established, things are taken care of early before you have a lot of members or what have you, and that pastor or that founder can appoint members of the board, that 3 that you appoint may be the 3 that you use for an extended period of time, if not permanently. Okay, you might decide to add here or there, whatever the case may be, but there is great privilege and deference to the founder being able to select his or her board member with those minimum requirements of 3, and they're not all related by blood or marriage. And so that founder may be able to appoint the entire board, may also want to create permanent seats for certain people or certain positions. The founder is always on the board. Perhaps the founding first lady is always on the board. Maybe the pastor's on the board, regardless of who is the pastor. Or you may also have other key positions. And so by appointing your leadership positions, if those leaders of ministries or auxiliaries, by virtue of their leadership of that minister or auxiliary, gets to sit on the trustee board, there may also be a way that you have some say over who gets appointed to the board. So if I say the head of the women's ministry has a seat on the board, well, how is the head of the women's ministry selected? And so it may be that the pastor gets to appoint the head of the women's ministry, and therefore, because she's head of the women's ministry, she's therefore on the trustee board or board of directors. Now, if that's the case, once again, I'll probably advise against having 100% of your board selected that way, but it may allow you to have a majority or a dominant group that perhaps is appointed on the board, or a sizable minority that could perhaps provide some type of insulation, if you will, in terms of some of the decisions that you may want to make as a pastor. So once again, number one, founders, you have the most control over who, how, and when people are selected for your board. Number two, theocratic churches that give great deference to the spiritual leadership and authority of the pastor in terms of appointments. But once again, those appointments should be affirmed or ratified by the congregation. And also, thirdly, you have your congregational churches or inherited churches, whereas you may have very little control, very little say, and you have to follow the rules that are established until you are in a position to perhaps get amendments made to your bylaws to perhaps tweak or change or modify some of the criteria and the voting procedures and the screening procedures for the selection of your board. The main point is, most churches, you must have a board. Second main point, most churches, the pastor cannot unilaterally appoint or fire or terminate that board. Thirdly, if the case in which the board has not been properly seated or given proper control, decisions by that board may be null and void, which can come back on the individuals on that board, in particular the pastor. So once again, I want to encourage you to review your bylaws as to what is your nomination and voting procedure, your criteria, your term length, your term limits, permanent seats, appointed seats, as well as grounds for removal and replacement. Once again, we want to thank you for viewing this legal lesson sponsored by the Law Office of Travell Travis. Our lessons, as always, are for educational and advertising purposes. It's not a substitute for consulting a licensed attorney in your state, nor does it create an attorney-client relationship. Once again, we ask you to like, to share, to comment on our posts, as well as connect with us on Facebook, Twitter, Instagram, YouTube, LinkedIn. Visit our website, travelltravis.com. Email us at travelltravis@gmail.com or call us at area code 757-528-8529. God bless you and have a great day.